I am Supriya Gill, a licensed lawyer, and in this video, I will guide you through the essential eligibility criteria and nuanced provisions within VAWA that determine who qualifies for this vital legal protection. Understanding these qualifications is important to ensure the safety and well-being of victims, while providing them with a path towards security and justice. The Violence Against Women Act, or VAWA, is a federal law that provides immigration relief to victims of domestic violence. VAWA empowers victims of domestic violence to self-petition for a green card, liberating them from dependency on an abusive spouse or parent for a lawful permanent address in the United States. To be eligible for VAWA, you must be a spouse, former spouse, child, or parent of an abusive U.S. citizen or lawful permanent resident, also known as an LPR. It is a necessary condition that the self-petitioner has suffered battery or extreme cruelty at the hands of the U.S. citizen or LPR relative, is residing with or has resided with the abuser, and is a person of good moral character. Besides these general eligibility requirements, there are some special cases where victims may still be eligible for VAWA even if they do not meet all of the requirements. For example, victims may still be eligible for VAWA if the abuser has died, if the abuser has lost their immigration status, or if the victim cannot live safely with the abuser. Specific eligibility criteria for different relationships under VAWA are spouses. Certain criteria need to be met to be eligible for VAWA self-petitioning as a spouse. The victim must be a spouse or a former spouse of a U.S. citizen or lawful permanent resident. The victim must have been battered or subjected to extreme cruelty by the abusive spouse. At the time of filing the petition, the victim must be residing in the United States. Eligibility at the time of filing is immaterial to marital status. The victim can file a self-petition for a green card under VAWA, regardless of their marital status at the time of filing. This implies that the victim can still petition for VAWA if the victim is still married to the abuser or has divorced the abuser, but up to 2 years after the divorce. Former spouses. The victim can self-petition for a green card even if they are no longer married to the abuser. There are certain criteria that must be met to be eligible for VAWA self-petitioning as a former spouse. The victim must have been the spouse of the abuser, a U.S. citizen, or lawful permanent resident. The victim has been battered or subjected to extreme cruelty by the abusive spouse or abusive former spouse during the duration of the marriage, or within 2 years of the termination of the marriage. The victim must be residing in the United States at the time of filing the petition. There are certain eligibility criteria that must be met to be eligible for VAWA self-petitioning as a child. The victim must be an unmarried child of the abuser, who is either a U.S. citizen or a lawful permanent resident. The victim must have been battered or subjected to extreme cruelty by the abusive parent or by a parent's spouse or partner. At the time of filing the petition, the victim must be residing in the United States. Even if the victim is over 21 years of age and is married, the victim can still self-petition under VAWA before turning 25, and he or she needs to demonstrate eligibility to file for VAWA when he or she was under 21 years of age. There are certain eligibility criteria that must be met to be eligible for VAWA self-petitioning as a parent. The victim must be the parent of an abusive U.S. citizen child. The abusive U.S. citizen child must be at least 21 years old. The victim must have been battered or subjected to cruelty by the abusive child. The victim must live with or have lived with the abusive child. At the time of filing the petition, the victim must be residing in the United States. The victim needs to demonstrate a bona fide parent-child relationship by providing evidence such as birth certificates, financial records, school records, medical records, and so on. Now let's talk about the general eligibility requirements for VAWA. First, there must be a qualifying relationship between the victim and the U.S. citizen or lawful permanent resident. This relationship can be as a spouse, child, or parent. Second, the victim must have suffered battery or extreme cruelty at the hands of the qualifying relative. Battery includes physical assault, sexual assault, etc. Extreme cruelty includes psychological or emotional abuse, threats, and so forth. Third, the victim must be residing with or have resided with the abusive relative at some point in the United States to be eligible for VAWA self-petition. However, there is an exception if the victim is unable to reside due to the abuse. Lastly, the victim must be of good moral character to be eligible for the VAWA self-petition. This means the victim must not have committed any serious crimes. Special cases of VAWA eligibility. There are certain special scenarios where the victims of domestic violence may still be eligible for benefits under VAWA, even if they would not otherwise be eligible. First, death of the abuser. The victim may be eligible for VAWA relief even if the abuser dies. Because VAWA law recognizes that the death of the abuser does not eliminate the need for protection for the victim. There are certain requirements to be met by the victim to be eligible for VAWA relief based on the death of the abuser. The victim has been married to the abuser. The victim has been battered or subjected to extreme cruelty by the abuser. The victim filed the petition within 2 years of the death of the abuser. Second, abuser losing immigration status. The victim may still be eligible for VAWA benefits if the abuser loses their immigration status. The reason for this is that VAWA recognizes that the loss of the abuser's immigration status can leave the victim vulnerable to deportation or other forms of harm. Third, inability to live safely with the abuser. The victim may still be eligible for VAWA benefits if they are unable to live safely with the abuser. This could be due to a number of factors, such as the abuser's continued threats of violence, the abuser's stalking of the victim, or the abuser's controlling behavior. The victim must also show that they have been residing in the United States with the abuser for at least 3 years. Fourth, undocumented victim with a U.S. citizen abuser. An undocumented victim of domestic violence may be eligible for VAWA relief if their abuser is a U.S. citizen or a permanent resident. This is because VAWA law recognizes that undocumented victims of domestic violence may be particularly vulnerable to abuse and exploitation. The victim must have resided with the abuser for at least 3 years. Additional eligibility details for VAWA self-petitioning. First, same-sex spouses. To be eligible for VAWA self-petitioning, same-sex couples stand on the same footing as heterosexual couples. Therefore, a same-sex spouse of a U.S. citizen or lawful permanent resident may self-petition for a green card if the marriage is recognized by the states in which they live. Second, adopted children and stepchildren. To be eligible for VAWA self-petition, adopted children and stepchildren can petition on the same basis as biological children. Therefore, an adopted child or stepchild of a U.S. citizen or lawful permanent resident may self-petition for a green card. The only condition in cases of stepchildren is that the marriage between the abusive stepparent and the biological parent occurred before the child turned 18, and the abuse occurred while the child was residing with the stepparent. If a child was adopted before turning 16, they are recognized as a child for immigration purposes if their adoptive parent or parents have been taking care of them both physically and legally for at least 2 years. However, if the child has suffered abuse from an adoptive parent or a family member living in the same home, the 2-year rule doesn't apply. If an adopting parent adopts 2 biological siblings, one must be under 16 and the other should be under 18. A foreign national child can be recognized as a child if they were adopted in a country that signed the Hague Convention or if they are coming to the United States from a signatory nation. The Violence Against Women Act, or VAWA, has proven to be a beacon of hope and protection for victims of domestic violence in the United States. By providing the victims of domestic violence with a green card, VAWA eliminates the need for dependency on abusive family members for immigration status, thus providing a lifeline to those who have suffered cruelty. Thank you for watching. If you found this information helpful, make sure to give us a thumbs up and subscribe to our channel for more legal insights and updates. If you have any questions or topics you'd like us to cover, leave a comment below. Remember to stay informed and empowered. Your legal knowledge is a powerful tool. See you in the next video.